My name is Dr. William Nkea, and I'm an American, but I'm an African. I was born in Cameroon, Central Africa. Went to America 18 years ago, so I'm an American, but I guess from the way I speak, you know that I'm African. I was inspired to write this paper or to get on my course by an event that happened here in Germany about 130 years ago. Precisely in 1884, there was a conference in Berlin called the Berlin Conference to Partition Africa. And the country I was born in, Cameroon, was given to Germany. But when Germany lost the war, eventually it lost its colonies in Africa. So Cameroon was given to France and Britain, and I come from the English-speaking part. But I did my studies in French, so right now the English-speaking Cameroon is aspiring for independence, and they're having a lot of problems with the government. And I was inspired to write this paper about that situation. And the paper is called, I titled it, False Labeling by Governments to Deprive Citizens of Basic Human Rights. Human Rights and Democracy in Times of Greater Global Insecurity. I was at the United Nations in New York in September 2017. And I had the opportunity to talk to some representatives from my country. And I decided to write this paper. I will read it. In this paper, I demonstrate that terrorism and its related violence enhances global insecurity, and argue that the absence of a harmonized international legal framework on terrorism has given rise to a multifarious conceptualization of the term. The paper holds that the derogation clauses contained in major international and regional human rights instruments have been exploited by states to craft counter-terrorism. Counter-terrorism legislations that do not only target terrorists, but also restrict human rights and the democratic space. Between September 2001 and December 2015, the UN Security Council passed at least 33 resolutions condemning and/or proscribing terrorism and related violence across the world. These acts of terrorism have affected countries and cities across the world, including but not limited to New York, London, Bali, Nairobi, Bogota, Madrid, Istanbul, and Iraq. The deadly methods employed, its global dimension, and the resultant consequences on human life and property is compelling evidence that terrorism now constitutes a threat to global security. It is therefore a moral and legal necessity that states should maintain a heightened readiness to respond to imminent attacks and construct legislation in a credible attempt not only to prevent acts of terrorism, but also to fairly sanction suspects. Regrettably, counter-terrorism legislations have had a frightening effect on civil society and the human rights community across the world, especially in Africa. Perhaps it is important to note that while the universality of human rights is rooted in international law, its violation has been justified by the derogation clauses in the international rights instrument. A careful content analysis of the major international and regional human rights instruments reveals that there are many ill-defined instances of permissible derogations inherent in them. In other words, many of the human rights guaranteed in international human rights instruments are not granted in absolute terms. The right to derogation has allowed local authorities to derogate from both national and international law regimes that grant certain human rights. Usually, the derogation expands the government's power to impose restrictions on fundamental rights and freedom and to conduct searches and seizures, as well as censorship without due process. The universality of human rights protection notwithstanding, customary international law and treaty of law both recognize national security concerns as a permissible ground for derogation. For instance, Article 29/2 of the Universal Declaration of Human Rights, Article 4 of the International Covenant on Civil and Political Rights, Article 6 of the African Charter on Human and People's Rights, and Article 15 of the European Convention on Human Rights all grant state parties the right to derogate from their human rights obligations on grounds of national security. A major legal obstacle against the suppression of terrorism is that the concept itself is difficult to define. A harmonized international legal framework will standardize state practice and streamline counter-terrorism measures to conform with international human rights best practice. But there is no UN treaty on anti-terrorism, and the ad hoc efforts at the level of the UN have not been very useful. Absent any harmonized international legal framework, the practical legal implications are that states must introduce domestic legislation to suppress terrorism according to their respective subjective national values. While some of these national counter-terrorism measures have been necessary and appropriate, many more are disproportionate to the threat posed by national or international terrorism and the goal to improve national security. This has in turn produced a bifurcated and more often conflicting domestic legal definitions of the same concept. This conceptual dissonance has permitted states to adopt domestic legislations that are discordant with international human rights and democracy. The legal window for these repulsive domestic legislations are the derogation clauses in international human rights instruments. Operating under the caveat of national security, most states have adopted the principle of false labeling to introduce repressive legislations that have overly vague or broad definitions of terrorism to cover peaceful acts and to proscribe inter alia labor rights, minority rights, or human rights, or more generally, to limit any sort of political opposition. This in turn adversely impacted on human rights and democracy in many countries of the world. False labeling is a mischievous political maneuver by which a political opponent is deceitfully tagged as a criminal for the purpose of persecution and elimination from the political space. False labeling serves both as a deterrence to political pluralism and as a consequence for dissenting views and activities. When states use false labeling to unjustly identify and eliminate robust political opposition, or to deny genuine demands for political reforms under the guise of fighting terrorism, such countering terrorism measures will directly constitute a disproportionate interference with human rights. If false labeling is based on a person's political activism or dissent, then process of false labeling will in turn have a huge adverse effect in the democratic space. Historically, false labeling has been used as a political weapon to delegitimize and criminalize the activities of freedom fighters and human rights activists. Despite his heroic long-lived battle against apartheid, Nelson Mandela was still considered a terrorist by the USA because of his inclination to communism. In present times, anti-terrorism legislation in many countries are not used to prosecute terrorists, but often to serve as a camouflage to stifle dissenting voices instead of addressing genuine national security concerns. The domestic laws internationally contain overly broad and vague definitions of terrorism and give the police and security services unprecedented powers to deprive the citizens of their fundamental rights and freedoms. These laws are in effect tools of repression designed and used by local authorities to stifle its critics and political opposition and to criminalize the robust discussion of matters of enormous public interest and importance. In this way, domestic legislation has been used to target human rights defenders, minority groups, members of the political opposition, or other individuals, some of whom have been arbitrarily detained and subjected to torture or cruel, inhumane, or degrading treatment or punishment while in custody. For instance, in Chile, the definition of terrorism is excessively broad and has allowed charges of terrorism to be brought against members of community groups to prevent them from demanding land rights. In Kenya, the overbroad definition has allowed the Inspector General of Police to designate leading human rights activists and organizations as specified entities, equating them with terrorist groups and freezing their bank accounts. In Cameroon, where I come from, the definition is extremely broad to criminalize peaceful protests and sit-in strikes to demand constitutional reforms on the form of the state. In Ethiopia, anti-terrorism laws have been used to restrict the work of human rights defenders, dismantle independent civil society, and to jail journalists en masse. In Egypt, the anti-terrorism law has radically undermined the rights to freedom of peaceful assembly, association, and expression. In Saudi Arabia, the law on anti-terrorism was invoked against a prominent Saudi Arabian human rights lawyer, Walid al-Kahir, who was jailed for 15 years on a string of offenses, including inciting international organizations against the government and breaking allegiance to the ruler, among others. My concluding remarks. From the foregoing, it appears that there is an international conspiracy to subvert human rights at the mention of terrorism. This should not be the case. The foundational principles of the United Nations Charter are rooted in peace and human rights, not peace on human rights. I therefore share the same sentiments with former UN Secretary General Kofi Annan when he said, and I quote, "We should all be clear that there is no trade-off between effective action against terrorism and the protection of human rights. On the contrary, I believe in the long term we shall find that human rights, along with democracy and social justice, are one of the best prophylactics against terrorism. While we certainly need vigilance to prevent acts of terrorism and the firmness in condemning and punishing them, it will be self-defeating if we sacrifice other key priorities such as human rights in the process." Kofi Annan, 18 January 2002. Measures must be taken to ensure a transparent terrorist listing and delisting process based on clear criteria and with an appropriate, explicit, and uniformly applied standard of evidence, as well as an effective, accessible, and independent mechanism of review for the individuals and states concerned. At a minimum, the standards required to ensure fair and clear procedures must include the right of an individual to be informed of the measures taken and to know the case against him or her as soon as possible and to the extent possible without thwarting the purpose of the sanctions regimes, the right to be heard within a reasonable time by the relevant decision-making body, the right to effective review by a competent and independent review mechanism, the right to counsel with respect to all proceedings, and the right to an effective remedy. However, these can only be achieved if there is a genuine global push for a harmonized definition of the term as a means of confining the concept. To conduct this is of a genuinely terrorist nature. Thank you so much for listening.
So once again, we're moving to the Q&A portion. Please stand up and say your name.
My name is Lorenzo Fiorito. That's the system for months. And I will interview right now. First of all, congratulations to your fans. I'm going to need to inform you that I just been a school student and we have had many interactions with organizations that can respond to the I just wanted to ask regarding your criticism of terrorism. Kind of movement is one that has encountered many of the same difficulties that we're talking about in terms of legal purpose, so that people are detained without being charged, sometimes indefinitely for people who use it. I was struck by the absolute similarities with, do you believe that this is coordinated, or do you believe that it's essentially states acting in their own place?
Well, I think it's coordinated. It's not states acting in their own interest, because most of these countries are not free. Cameroon is supposed to be independent, but it's not free. We have a colonial master called France, and we still use French money. We still have military cooperation with France exclusively. So I think that we're really not free as we ought to. We are free in the book, but not free indeed. So most of these things are difficult to identify because the sources are somewhere in Europe. They are rooted somewhere in Europe and not in the place itself. So I don't believe that Cameroon is free. I don't believe it's independent. I don't believe the president has the right to make certain decisions. I think he's just a stooge.
Do you have any more questions?
And from here, I'm traveling to Cameroon. I intend to meet with him and, asking some of these questions myself. I tried to meet with him at the UN, but he was hiding in Trump Hotel. Yeah, I couldn't meet him there. So I hopefully I will meet with him, and if he gives me audience, I will ask him some of these questions.
I think with that, we'll conclude this portion of the talk. Please let's thank Dr.